Senator McFedrin.
Merci. Alors, bonjour, Tanzi.
Thank you.
Sénatrice du Manitoba,
As a senator from Manitoba, I acknowledge that I am on the traditional territory of the Anishinaabe, the Cree, the Ojibwe, the Dakota, the Dene, and the Métis Nation. I wish to state that the Canadian Parliament is situated on Algonquin territory, Anishinaabe, which is unceded and unsurrendered territory.
I rise today to speak to Bill C-22, the Canada Disability Benefit Act, with appreciation to Minister Qualtrough and the bill's sponsor here, Senator Cotter, for best efforts to shepherd it through the legislative process culminating in our review today. Many parliamentarians understand how crucial this bill is, long overdue and deserves support for millions of people with disabilities across Canada who live in poverty. We can be proud of the thorough and thoughtful contributions made by members of the Standing Senate Committee on Social Affairs, Science and Innovation, or SOCI, and of the trust placed in us by colleagues in this chamber in their support for these amendments, resulting in a stronger Bill C-22 returning to us today with all but one of our 6 amendments incorporated. The accepted amendments include an appeal mechanism by which applicants may contest decisions about their eligibility to receive the benefit and the amounts to which they are entitled. Also adopted was the expanded list of factors that must be considered in the benefit calculation, among which are Canada's poverty line, the costs created by systemic barriers to accessing work, the intersectional needs of applicants, and Canada's human rights obligations as they relate to the disability community. The final amendments accepted are those that provide for an expedited implementation timeline for the benefit by requiring that all the regulations must begin to pay out under the Act be in place within 12 months of the new Act's coming into force date. These changes bolster this Framework Act by ensuring crucial implementation mechanisms rather than risking them to the uncertainty of regulations yet to be drafted. Just one amendment has been rejected. I doubt Senator Gold intended to ghost me, but it was proposed by me on behalf of disability rights experts and organizations. Proposed for Clause 9C of the bill, this amendment would have protected recipients of the Canada Disability Act by preventing private insurance companies from deducting the amount of the benefit paid out under the Act from payments made under long-term disability policies. These clawbacks by private insurance providers were not discussed in committee in the other place, but they were studied extensively when Bill C-22 was examined by the Senate SOCI Committee. The amendment to stop rich insurance companies from clawing back the benefit from poor people with disabilities was endorsed by over 40 legal aid clinics, community leaders, academics, disability advocacy groups. On the question of its constitutionality, every provincial trial lawyers association in Canada supported the amendment as viable in law. And so, we have before us a bill that enables private insurance companies to claw back the new publicly funded disability benefit, regardless of whether Minister Qualtrough calls it a social benefit or not. Many private insurance contracts are clear that they can set off any government benefit, effectively subsidizing private insurers instead of providing additional financial support for members of the disability community as intended by the Act. Colleagues, concerns about industry clawbacks are not far-fetched or hypothetical. Clawbacks are happening now to available public benefits. Old age security benefits, for example, are already explicitly set off from long-term disability payments by many private insurance companies, while similar deductions have been made from insurance payouts to recipients of the dependent benefit under Canada Pension Plan. Further, the courts have sided with private insurers. For example, In a 2008 class action, the court affirmed the legality of deductions from long-term disability payments of this nature, absent any provision in either the policy or in the legislation prohibiting it. And private insurers leapt to enforce those deductions through litigation against disabled recipients. For example, in the case of State Farm Mutual Automobile Insurance Company, the appellant insurance company sought to enforce the deductibility of the CPP dependent benefit on the basis of the 2008 class action ruling. And in Industrial Alliance Insurance and Financial Services, Inc., the private insurers sought to enforce deductions from a long-term disability policy in the amount of benefits received by the policyholder under both the Canada Pension Plan and the Public Service Pension Plan. Time does not allow me to list the many other cases wherein private insurers went to court to claw back payouts under long-term disability policies premised on the policyholder's receipt of public benefits. The rejected amendment prohibiting clawbacks of the new benefit by private insurers would have done what the courts have said needed to be done in order to protect recipients, to ensure that benefits are received by those for whom they are intended, rather than function to subsidize private insurers. The time to respond to this concern is sooner rather than later. When the CPP dependent benefit offset was challenged in 2008, industry relied on the fact that its premiums were adjusted on the assumption that it could offset CPP benefits, but held that without the availability of that offset, insurance premiums would undoubtedly rise. No such adjustment can presently be relied on by industry in relation to the Canada Disability Benefit, as premiums taking the new benefit into account have yet to be calculated. Concerns were raised at SOCI and in this place as to the constitutionality of a provision that engages with the insurance industry by purporting to regulate insurance contracting as falling outside the jurisdiction of the federal parliament. The fact is, such a provision is not unprecedented in Canadian benefit regimes. For 40 years, the Merchant Seaman Compensation Act, for example, has protected recipients with wording closely similar to that proposed in the rejected amendment. 40 years, honourable colleagues, with no court challenges, constitutional or otherwise. Another relevant precedent can be found in the 2020 reference Genetic Non-Discrimination Act, which grappled with the constitutionality of a federal legislative scheme to regulate aspects of insurance contracting by preventing private insurers from requiring genetic test results as a precondition for health insurance eligibility. In reviewing the legislative scheme, the court determined that its overall goal was not regulation of the insurance industry per se, but rather the prevention of genetic discrimination in the provision of goods and services, such that the insurance provisions at issue comprised only part of a broader regulatory scheme and were necessary in order to preserve the purpose of the federal legislation. Sound familiar? Absent the Act's protective insurance-related measures, the scheme's purpose would be seriously undermined, justifying the minor incursion into a matter traditionally falling within the ambit of provincial jurisdiction. These real-life cases support the viability of a provision like the rejected amendment, prohibiting set-offs by private insurers of payments under the Canada Disability Benefit Act. It is clear in the Act that the Canada Disability Benefit is designed to be supplementary for those who qualify under the Act. The legislative purpose of making a supplementary sum available to eligible recipients is undermined if private insurers are permitted to correspondingly claw back payments under their policies because, in practice, the recipient is left with substantially the same amount they were receiving before introduction of the benefit. Absent this simple operational protection, the bill before us today will effectively indemnify private insurers and deny the intended recipients the benefit. Lifting disabled people out of poverty is the stated fundamental purpose of this bill. And in this regard, it will become a mockery of Minister Qualtrough's promise to disabled people who desperately need and deserve the Canada Disability Benefit. The exclusion of this amendment to prohibit benefit clawbacks by private insurers is a choice the Trudeau government has made not to ensure that certain eligible recipients under the Act receive the full supplemental benefit promised to them. Time will tell how many private insurers will exploit this loophole given to them. And perhaps, someday, Parliament will have a second chance to bring justice to those disabled recipients who are now exposed to the legal force of rich private insurers. But let's not pretend that the real cost will be borne by poor disabled recipients who will be made to suffer because this government chose not to protect them. They will suffer, and the cost will be borne by them. Last week, Senator Pate and I received a letter from Mr. Duncan Young, whose standard of living is determined largely by a private insurer. I share the following with his permission, and I quote, "I am not one of the many selfless volunteers who advocate on behalf of the disabled. Neither am I an activist or lobbyist for any such person or group. I am simply an average 55-year-old working-class Canadian who happens to love his job and is looking forward to working at it for as long as he can. Or at least I was. 3 years ago, I received a diagnosis of spinocerebellar ataxia 3, an extremely rare hereditary neurological disorder that causes the cerebellum to atrophy, thus completely destroying a person's motor skills, impairing walking, talking, swallowing, bladder control, etc. It is progressive, has no known treatments to abate its development, and there is no cure. Of note, an affected person typically does not present symptoms until somewhere between ages 40 to 55, meaning I, and most like me, are enjoying a full life still in its ascendancy when suddenly your brain will not allow your legs to form the motion necessary to let you run to catch the bus, or let your fingertips stay still long enough to do up the tiny buttons on your button-down collar. I'm continuing with the statement from Mr. Young. Let me be clear. Without that amendment enshrined in statute as worded, I will receive $0 from the creation of the benefit. It would be, in its entirety, an eligible clawback according to my limited provider's contract. In short, the only beneficiary of such a benefit would be the shareholders of a publicly traded insurance company, while I continue to slip below the poverty line. Both points here are not conjecture. They are quantitative facts. So you know exactly, unquestionably and with detail, exactly what the passing of C-22 without this amendment will mean to myself and every disabled person in similar positions. Nothing. End of quote. I'm so sorry, Mr. Young. But at this stage, we must hope that Minister Qualtrough and this government can somehow turn this around by actively convincing provinces and territories to ban private insurance clawbacks of the CDB within their respective jurisdictional authority. Such advocacy should not be left, again, to the disability community to take on alone. Honourable colleagues, we all know this disability benefit is long overdue and desperately needed. The disability community in Canada has advocated for stronger and more reliable income support for far longer than this bill has been in contemplation by Parliament. I am grateful for the many insightful comments and valuable contributions to the development of this bill from community leaders and advocates, both in committee and in various other capacities. Mindful of time, I can acknowledge only a few, extending appreciation for the legal expertise provided by witnesses to SOCI who brought the clawback to our attention: David Lepofsky, Robert Latanzio, Stephen Muller, and Hart Schwartz. For the sake of those eligible recipients who are unlikely ever to see a penny of the Canada Disability Benefit, I fervently hope that these experts will continue to be vital contributors to the Minister's promised consultations to fill in the framework legislation. Let us now pass this bill into law before we leave for the summer. Thank you. Merci. Miigwech.